confirm that we're live. All right, welcome to a very special edition of our Ask the Judge video series, because you hear from me way too often. And so now we're doing a special edition of Behind the Scenes with our Sheboygan County Prosecuting Attorney, Melissa Goodrich, and James Gilbert, who is a public defender both in Sheboygan and in Presque Isle County. And thank you both for taking time out of your busy schedules to join us for this video, where we'll have a chance to answer some questions that viewers have submitted about our roles in the justice system. So first off, do you want to introduce yourselves? Melissa, starting with you.
Melissa Goodrich, I'm Sheboygan County Prosecutor.
And good afternoon, everyone. My name is James Gilbert. I'm one of the public defenders for both Sheboygan and Presque Isle County.
All right. And for purposes of this video, I think for us just to have a free discussion about these topics, I would propose that we've all known each other for a number of years, that we would just refer to each other by our first name. It's not a court appearance. So please, say, hey, Aaron this or Aaron that, and I'll do the same with you both. Does that sound all right?
Okay. Great.
Sure. It's going to be tough.
All right. So the first question I thought we could answer is describe how you view your role in the criminal justice system and share some information about what you do behind the scenes when you're not in court on the record. So Melissa, how about you first?
Okay, I can kind of talk about how a case goes through the system as far as what my role is in that. I receive a police report from law enforcement. I think a lot of times people are confused that we can take action before receiving police reports or just simply take complaints like a 911 call type complaint, but we don't do anything until we receive a police report from law enforcement. And once we review that, we see if that there's enough evidence in order to charge a crime. And once we charge that crime, then we attend a series of court hearings, and a defense counsel is either retained or assigned and go through the case that way. If we deny that there's enough to charge a crime, then sometimes we'll go back to the police officers and ask for further investigation, or we'll contact victims and talk to them about what our decision was and why. For the behind the scenes information, I guess, in between court hearings, or sometimes we're asking for adjournments, is that we're in constant communication with the defense attorneys on how to proceed in the case, how to resolve the case, as well as if a victim is involved. We talk to them every step of the way if they choose to activate their victim rights and get their input too on how the case is proceeding. Sometimes the cases can be fluid, so we're asking for additional discovery, either some more information from the defense as to their clients or their versions of what happened, or from law enforcement.
Okay, thanks. That gives a lot of input. And as you're deciding whether to issue a charge, then are you viewing, whether you believe there's enough for you to secure a conviction at the end of the case, as well as the probable cause standard, or what kind of goes into that thought process?
Correct. Whether there was enough for the arrest, as well as if we go to jury trial, whether we can meet the beyond a reasonable doubt standard at that time as well.
Do you have any sense of, and if I ask a question that's not fair, just go ahead and say so. Do you have any sense of what percentage of cases or number of cases in a year or a month are denied for issuing of charges?
I think that we work with such excellent law enforcement that it would be a small percentage of cases that are denied.
Okay, good. Jim, what about you? How do you view your role in the justice system, and what do you do when you're not in court?
Well, thank you. I was going to say, Your Honor. Like I said, it was going to be tough. And I'm over here taking notes. I felt like I was in the presidential debate there for a minute as I'm writing down things. But as for the public defender's office, we have certain criteria. And at the arraignment, if a person's arraigned right after they're initially charged with an offense, they're asked about whether or not they are going to retain their own attorney, or they're going to be asking for, and we now are called the Office of Assigned Counsel. They're asked that at that time, if they want the office of assigned counsel, then we have to take financial information. The reason for that is that the public defender's office, and we get it all the time when I'm meeting with clients at arraignment, they'll just go, oh, this is an easy one. I'll just take the public defender, or, I'll just take the public defender on this one. Well, the only people that get the public defender's office are people, A, that are indigent, and there's the probability of jail. So if you receive a ticket that there's going to be no jail time, you're not getting the public defender's office. And if you are not indigent and have a good job, can afford your own attorney, that's what you're supposed to be doing, is hiring your own counsel. So we have to make that determination whether or not it comes through our office. In the area that we're in Sheboygan, there's a lot of people that fall into that category. And so we have a very large caseload. And then one of the 3 public defenders in Sheboygan or 2 in Presque Isle will get assigned to these cases. Now, a lot of times I hear, well, you're a defense counsel, you're just trying to get everybody off. You want to have guilty people all on the streets. It's not that type of situation. You have to remember the defense counsel lives in the community too. We don't want guilty people just roaming the streets. I sort of view a lot of the time, because the majority of the time my clients are guilty, that my job is to try to minimize the penalty that they might be exposed to. So for instance, a lot of times, I'll hear clients say that, well, maybe I should go into one of the treatment courts, a sobriety court or a recovery court. And I have to be frank with them. If you plead guilty to a different charge, you're going to serve this much time in jail. You're not going to do well in a recovery court or a sobriety court. You're not going to succeed. And at the end of the day, your penalty might be a lot larger. So I'm always talking with clients, trying to make sure that we minimize their penalty as much as possible. The other thing is to protect their rights. Melissa made a good point about that. We do have very good law enforcement in this area. And so they do their job very well. But we also have to make sure that the citizens or the possible defendants, their rights are protected at all times. And that's another big role when we play. And in regards to communication, when we're not in the courtroom, is Melissa and I probably talk as much as anybody does. We text each other. We're on the phone together. We bump into each other in the hallways, always talking about clients, how we're going to resolve cases. There's a great deal of talking back and forth. And a lot of times it's to come up with a resolution that seems fair to everyone, that the victims are protected or are taken care of, their needs are, but at the same time that it's not an over punishment for the defendant. And so that on a daily basis, those negotiations go on.
Okay. And from my perspective, the things I'm not doing when I'm not in court is, number one, preparing for court. Every time we come into court, each one of us has had to read and review different documents, especially for the sentencings. We talk about the pre-sentence reports. And, I don't know if people understand that for every felony sentencing, at least, there's a written pre-sentence report about the case and about the defendant that's anywhere from 15 to 30 pages long. And you both know about the case, know a lot of those things already, and I know none of it usually. So it takes a lot of time to read all those and get ready for the court. Some of the other time I spend is various administrative duties that we have. There's the office staff that helps out with all sorts of different functions. There's the state court administrator's office and the Michigan Supreme Court come out with different rules of procedure. We work with the clerk's office and with different attorneys and with the probation officers to change some of the systems of how we do things. So those administrative duties take a great deal of time as well. And then just as we all do, staying up on the law, that takes time to read the cases and go to trainings and that. And my role is really to be as neutral as I can. Humans are humans. And so people, have opinions. But, the role of a judge in the system is to, as much as humanly possible, set those things aside and decide the case fairly to both sides. And I will say that, when the cases come in front of me, my primary concern is whether the process is fair and everybody understands what's going on. I really try to keep out of my mind, whether I want one side to win or not. That's not important to me at all. There were some interesting questions that came in about us and how we deal with the cases kind of personally. So how do you remind yourself to stay grounded and not become overwhelmed or overly emotional during tough cases? Any input about that?
You want to go first this time?
I can. The thing is, you do get emotionally attached to certain cases. And, there's ones that have come through our circuit court in the last month or so that I've had experiences with it, not acting as the defense attorney, but acting in different capacities for other courts that I was involved with the case in one way or another. And you do get emotional. How you keep grounded, I guess it's just that after a matter of time, you get used to it. And so I guess in general is that you're not always grounded. No one is. Sometimes you do get emotionally attached to the cases. However, I think over time you learn to, your skin gets a little bit thicker and you don't get as attached that often. I guess that would be a good way to sum it up.
Yeah, I think that's fair too. And for all three of us, we've been involved in the criminal justice system a long time. And I find if I'm at family functions or social functions, and I'm just talking about work in general and start telling some story about an old case, I'll say something that I think is perfectly normal. And then all of a sudden I see the horrified looks on the people around the table. And I realize, oh my goodness, I forgot that I've got a thicker skin about this because I deal with it so often. And sometimes what we deal with is pretty shocking. But, I think during a case, what helps me is, and I think this is only for my role, is trying to consider all sides. So whenever I feel myself start to get emotionally pulled in a case, I mentally step back and remember that I have to consider all sides. So I'm not just considering the impact of the case on the crime victim, because that can be very emotional sometimes. But then I have to stop back in my role and also think about what is the impact of this sentence on that defendant and on the defendant's family. And that sometimes is quite emotional as well. And so I have to step back and consider all those, and also then the larger community as a whole. But in general, I think what helps me is just having some positive connections with other people outside of the court system, and finding out, for each lawyer, what recharges you, what refreshes you, what relaxes you, and doing those things, because I think you're right, Jim, that to say we're always grounded about it is just not right. I mean, that there are plenty of times where I've had to step off the bench and close my door and take a few minutes to compose myself after a case, because it's pretty tough. And Melissa, I'd be really interested in your perspective, because in your chair, you have to talk directly with victims of crime much more than either Jim or I do, and how you manage some of the stress and emotion of that.
Yeah, and I think keep reminding yourself that you are in the courtroom and supposed to be the unemotional voice, trying to handle a case. And also kind of, as you talked about, the respect of everybody in the courtroom, that you stay unemotional during the hearings, because everybody has their own viewpoint about what is going on. I think what has surprised me as prosecutor is even when it's well-deserved and someone's going to prison, how difficult that is and how that never gets easier, because you realize the ramifications on not only that person's life, but their families and everything that's involved in that, that has not become any easier. But certainly there's rewarding moments too, when a victim feels like they were heard and believed, and going through that with them makes the job so wonderful. But also rooting for the defendants at times, such as in our recovery court program, when we get to see somebody who has an addiction and they were able to treat the addiction and become better citizens in our community. And I think that people assume prosecutors are just sitting there rooting against the other side, but I love that scenario when we actually get to help.
Yeah, that's a great point too. And I think that that's super helpful for our participants to have you on the team. Here was another kind of personal question. What's your least favorite task to do in your day-to-day job duties, and why is it your least favorite?
That one's easy for me. My least favorite is when I have to prepare a child to testify at trial and go through their story, because from what I've read, that it's just as traumatic as the first time that it's happened to them. So that is easily the least favorite part of my job, because I feel like I'm contributing, I'm actually causing some harm to them by preparing them for that trial, even though it's necessary.
Wow. Okay. For me, I think that the least favorite task that I have is the times when I have to impose a sentence that is like decades long, and that I know is just a life-changing sentence for that person. Even, I only give those sentences when I believe that the law and justice requires it. And so I understand that it's a good thing for that sentence to be pronounced, but it's a hard thing to do, and it never brings me any personal satisfaction, because it just weighs heavily that's a human being, and I just ordered them locked up basically for the rest of their lives, or for decades of time, and that's my least favorite thing to do.
See, and I read that question a little bit different. I was looking on a daily basis. So what I was thinking, my worst thing on a daily basis, the two of you have this very profound thing that happens occasionally, but mine was chasing people down daily. Every day I hear this person's not accepting telephone calls and their voicemail's full. Drives me insane.
Okay. Oh, there you go. Yeah, that's good. Yep. So growing up in school, middle school, high school, did either of you have your mindset on criminal justice, or did that happen later in life?
Am I going first this time, Melissa?
Sure.
Well, my father was an attorney, so that probably already had it set in my mind. I've always been the legal. I grew up in a legal family. The joke was, though, I was the only one that did not work in my dad's office as some sort of intern. My two sisters had, and I'm the only one that was dumb enough to become an attorney. So they knew what they were getting themselves into and didn't do it. So I think mine was probably mostly motivated by following in my father's footsteps.
Okay. Melissa, did you always want to be a lawyer or be involved in criminal justice growing up?
So surprisingly, in 5th grade, I decided that I wanted to be a lawyer, but then it took 3 schools and 4 majors to end up doing what I started doing. So there was other things considered.
Yeah, that's similar to my story. When I was a little kid, I wanted to be a lawyer. Some of that may be my uncle, Joe Kukuski, who just passed away, was the Sheboygan County Prosecutor. And I grew up just looking up to him, and he was my hero. And I loved following after him in some of those cases. And he let me be his gopher for a couple cases in high school, a murder case even. And I just fell in love with the law by watching his passion for it. And it's something I always wanted to do. But I did get sidetracked and did some other majors and some other jobs before I got around to it. But I'm really glad I did. Any advice for someone who is young and would want to work in the court system as a lawyer, or even a court reporter or clerk or police officer, or involved in the legal system in any way? Any advice?
My advice is to call whatever office that you're interested in doing and asking if you can job shadow, whether it's for a day or a semester. I know in the prosecutor's office, we always try to pay it forward, and we've had college students who want to be lawyers sometimes just visit us for the day and come see a circuit court docket and watch it. And we talk to them about it before the docket happens and then have them sit through it. Right now we have a senior high school intern that's interested in going to law school, that is viewing a lot of courts and interested in our office and comes daily for that. We also plan to have a law school intern next summer, spend 12 weeks with us and get experience in the courtrooms. So I think whether it's you want to be a lawyer or a court reporter, to just be able to follow that person around and see what they actually do, I think most people would be surprised how many other jobs there are other than just the judges and lawyers.
Okay, good. Anything to add to that, Jim?
I was going to echo the exact same thing. If somebody's interested in this occupation, you definitely should do an internship and or shadow, like Melissa talked about. Because to be honest, after I passed the bar and started practicing law, I didn't like it. I did not like general practice. I didn't like doing divorces. I didn't like doing real estate. There was a lot of things about the practice of law I just thought was boring. And now, at the time, it sounded great while I was in law school, but then when the practicality came, I didn't care for it. And the same thing is, we talked about our other professions. Before going to law school, I was a CPA. And while you're doing it in school, yeah, the numbers and all that, it's fun solving the equation, but the actual practice was something I didn't care for. But there are different aspects to the legal profession. I have a job now that I absolutely love. I enjoy going to work, but on the other hand, it is not for everyone. It's very stressful and it's anxiety ridden. And as we talked before, sometimes we're just not grounded and it is emotional, but I would really investigate where in the judicial system or any job opportunity before diving, feet first into it.
Okay, good advice. We had a couple of questions about criminal procedure. One of them, the more general one, is why do some cases seem to take such a very long time to get through the court system? Any insight into that? I mean, one of the things right off the top of my head, the people that are viewing this, nothing was on YouTube before COVID. And so probably 66%, 2/3 of the reasons for the delays have been COVID related almost directly. So people watching it are seeing cases take longer to get through the court system than is typically the case. There are time guidelines that the state gives us that have been sort of waived for now, but outside of the time of COVID and once we're through the backlog, just as an example, in criminal cases, we're supposed to have 70% of felonies resolved within 90 days of the bindover. And we're supposed to have 98% of them resolved within a year. And so, we've got some time guidelines to follow, but COVID's rendered them impossible. Because if people wanted a trial, we had to, delay that for quite a while. Any other perspective that you guys have on why do some cases seem to take so long?
Well, I think you hit it right on the head. COVID has delayed things a lot, and and we all know that we had no trials for almost a year, and so those cases have delayed much longer than they would have before COVID, or then hope to delay after COVID in the near future.
Okay,
I would agree. It takes time, and then when you're wanting to meet with people or coordinate with people, everything is just taking a little longer right now.
Yes, and even aside from that, sometimes, and it's important for people to remember when they watch some of these things. If you watch long enough, you're going to see all three of us on this screen right now be irritated with each other at some point about some case. I'll be irritated at Jim. He'll be irritated at me. He'll be irritated at Melissa, vice versa. All of that, because there's so many things happening, and three human beings have three different perspectives on those cases from time to time. But despite any of those things you might see, it's recognizing that any delay in a case is almost always then because if it's not COVID, you guys can't just decide on the spot, here's what should happen in this case. You both have folks you have to talk to. You've got victims or police officers to talk to, or the defense attorney has the defendant's family. Maybe the defendant's incarcerated and he needs to communicate with his family about a plea before he decides to take it. Maybe you need to check with a witness or follow up a lead to see if there's a viable defense, so all of those things. So that has to always be remembered too.
And then all those people are dealing with their own COVID emergencies or restrictions with their own families and so forth. So it compounds that way.
Yeah, that's true. That's true. We got a detailed question about forensic exams. That's the psychiatric exam for whether someone's competent. At the arraignments, I always ask the defense attorney whether a forensic exam is requested. And somebody asked, well, does the prosecutor get any say about that?
We do. It can be by a motion. Unfortunately, we really don't have any direct contact with the defendant, only in a court setting when they're sitting next to their attorney. So I usually rely on the defense attorney's perspective on that because they're the ones dealing directly and having conversations and spending a lot of time with the defendant.
Yeah, and the court can even enter that. So the law does allow any of us to request that at any time, not just the arraignment. But I asked the defense attorney at the arraignment for exactly the reason you said, Melissa, that they're the ones that have the most direct contact with the defendant and might know if there's an issue that we need to look at there. But at any time during the case, if any of the parties think that issue is that there's a mental health issue, that can be raised. And I have seen that raised by a prosecutor, I think once in the last year. I forget if it was you or Mr. Radzban and Presqu'île, but that can happen. Question about sentencing. When we say that's a 5-year felony, what does that mean? Is it the minimum or maximum? That's an easy answer. It means the maximum. It doesn't mean that that's what they're going to get. That's the maximum they could get. And the reason you hear me say that all the time is because we have to advise the defendant what the maximum penalty is before they would enter any plea so that it's voluntary. They know all the facts. But this I thought was an interesting question. Do comments by the defense, or I guess by the prosecution as well, do they affect the outcome at sentencing? So at sentencing, when you both say things, I guess what goes into your decisions about what to say, and do you think that it matters?
I know I read through the pre-sentence investigation. I also talk to victims before the sentencing, but also the day of sentencing, I do listen to what the defense attorney and the defendant have to say. And sometimes that does impact what I have to say, whether it's important to me if they are holding themselves accountable to what they've pled to, or if they're doing any type of victim blaming, that's certainly upsetting. So that can vary what I have planned to say that day.
Okay.
Well, and I guess when I'm allocuting for a client at the sentencing, I'm thinking mostly of what will put my client in the best light to the judge. And that's what I try to bring out so the judge sees those positives. A lot of times, maybe the client's been very proactive. Maybe everybody makes mistakes. Defendants aren't all bad people. There are some. However, people make mistakes, and sometimes you have a client that's very proactive, out doing community service, they identify that they have an abuse problem. They're already in AA. They're already seeking counseling. That's a lot of things that I think the judge needs to know. And I absolutely believe what I have to say affects the judge's opinion. I can count on numerous occasions where we've had a PSI, a report that gives a recommendation to Judge Gauthier or any of the judges that I practice in front of. And after I'm done talking, the judge does something completely different than the recommendation. And it's obvious that it was based off of what either I said or what Melissa said.
Yeah, and I can say, I prepare for sentencing by reviewing that pre-sentence report, reviewing the file, and I prepare a single-page worksheet of my own that has various factors that I think are the most important to me. And then it culminates with some notes to myself about what my anticipated sentence is before I come out. And so I've got that written down in 98% of the cases. Sometimes it's so strange, I've just got a big question mark by that, and I wait and see what happens that day. But most of the time I have it written down what I think I'm going to sentence. But many times, the sentence that I pronounce is not the sentence that I wrote down as notes to myself, based upon what the attorneys or the victim or the defendant has said at sentencing. The victim impact statements are sometimes quite powerful because they bring some of the details of the case that didn't come through in the police reports or in the pre-sentence report. So that's a real helpful thing. And hearing, I think that's the hardest decision for a defense attorney. Like, how do you decide whether to recommend for your client to say anything or not? I can tell you, I never hold it against a defendant when they don't speak. But sometimes when they do speak, they hurt themselves, that's for sure. But other times when they speak, they really help themselves. So how do you as a defense attorney judge whether you want to recommend to them to say anything?
Well, as we were talking here, and I'll go back to another question. What's the worst part of our job is, especially during a sentencing, when the victims are talking, standing up, especially with a child victim or that type of thing, standing next to the defendant that done something poorly to that victim. That's probably one of the worst parts of my job, other than the telephone calls I mentioned earlier. But you sort of, when you're talking with your clients, there's a lot of times I say, I really don't, you have a right to remain silent. I think we need to use it because I know you talking is going to get you farther in, further in trouble, because A, you can determine that they're not remorseful, or they want to make it, and they want to make excuses, or they want to blame everybody else for that. And those are things that I just don't feel that they should say at sentencing. We had a case, Aaron and you and I had, where over in Presque Isle, and that was a couple of years ago, and I know this topic came up before, where we actually had a full trial. I won the trial, and then my client decided to just mouth off to everybody because he had won. Problem was, he also had a contempt hearing right after that for something he'd done while he was on bond. And so he ended up going to jail just because of his antics, how he was acting in the courtroom. And how often do you win a trial and your client still leaves in handcuffs?
Yeah.
So yeah, you just evaluate what, and he deserved it. There's no doubt about it. So you sort of have to evaluate and figure out if you think they're going to harm themselves.
Okay. Yeah, and the other related questions to that is issues like respect for the courtroom decorum or their attire. Does that have any impact on the sentencing decision? I mean, I'd say very, very little. I try to set those things aside. And then does the judge's mood affect the sentence? The only thing I have to say about that is I hope not. And if any of you ever think that's the case, maybe ask for a continuance or something. I don't know. There was one time in the last few months when a defendant started explaining during his allocution, and the statements he was making, I found to be so offensive that I found myself flat out mad at him. I was angered by what he said. And I was so angry, I actually said, I'm too angry to sentence you right now. So we adjourned it and came back a month later for me to, reconsider with more of a cool head, I guess. So that's the only time I can think of that my mood was starting to interfere, and I tried to prevent that.
There was a study, though, done a few years ago determining sentencings between how judges sentenced and how their college football teams had done over the weekend.
Well, it's a good thing I root for the best college football team in America, the Notre Dame Fighting Irish, then, because I'm always happy.
And there's a reason Melissa and I have a chart on when they win.
Right.
I was going to say, as far as the clothes too, I think it'd be important for the public to know that, sometimes it might not look like something you would wear to court, but really it's the best thing that person has in their closet. And I don't know if they realize that sometimes for trial, defense attorneys actually have to go shopping for their clients so that they do look well in front of a jury.
Okay, good point. There were a few questions about, there were a couple of questions at least. Why are some discussions held in chambers or off the record? What are the benefits of those discussions to be in private rather than in the open courtroom? Are they mainly just to streamload the caseload for the day, streamline it? So from your perspectives, why do we have those discussions, and what benefits do you think that they have for you?
Well, I guess I'll go first. I think I've let Melissa go each time, put her on the spot, but I can think of three right off the top of my head where we would ask for either a sidebar by the bench where we don't want to broadcast over the throughout the whole courtroom, or an in-chambers conference where both the prosecution and the defense are there. The first would be if it's obviously of a personal matter. The judge is sentencing a trial for a specific date, and I'm going on vacation. I don't necessarily want to broadcast that my house is going to be empty for the week of such and such, over YouTube or even in a courtroom on a criminal docket day. So to tell personal information to the judge and the prosecutor, so maybe we can schedule something at a different time. The other thing would be is I think it's something that might offend my client. There's numerous times that I'll ask for a sidebar and, tell the prosecutor and the judge that, and they wouldn't know this because they don't have the same contact. Well, that my client has a learning disability, or my client has mental issues, or it has some medical issue that maybe my client would be embarrassed if it was broadcast out in open court. So that would be another reason to protect the client from things just being put out in the public that they might be sensitive to. And then the other one I always think about is maybe I have a client that is going to work undercover or do something with law enforcement. Obviously, they're not going to be very effective if I announce that out in the courtroom and everybody hears it. So that's something the judge would have to know, and the prosecutor would know. The prosecutor would know that anyhow, but it's something that we should relate to the judge. So those are some items.
Okay. Anything to add to that, Melissa?
And similarly, if it's something personal about a victim that shouldn't be on the record, I think that the defense attorneys do a good job protecting them, and I try to do the same for defendants' personal information.
Yeah, I mean, I agree that sometimes it's a sensitive topic that would either be something personal to the lawyers or myself, or it would be embarrassing to the parties. Also, sometimes I appreciate when the attorneys will come talk with me ahead of time if there's a plea agreement that they want to place on the record that's really fairly unusual. And they know that, just on paper, I might look at that and say, well, what in the world is that about? But there might be reasons for that. And some of them might be sensitive reasons, just to explain, give me kind of a heads up on that. Or then just to give me like a heads up on some issue that's coming up. Or I know I have sometimes done that to the attorneys where I'll give you a heads up. Hey, I don't think I'm going to follow that sentence agreement. Here's what I think I might be doing, but I'll listen to what you say on the record, just so that I don't sandbag you all the time. I think sometimes that happens, but those sidebar conversations can be helpful so that we just have or like a guideline scoring issue. So I might call counsel in chambers or to the bench and say, hey, I have a question about OV 13. Again, we don't always do that ahead of time, but the times when I remember to do that, I think things go smoother. Similar to that, are there any rules in Michigan about ex parte communications between the attorneys and the court? Do they apply to email? And the answer is yes, they apply to email. Yes, there are rules. There are lots of rules about that. The gist of it is I'm forbidden to have a conversation with one lawyer without the other side's lawyer present if it's anything about the substance of the case. I am allowed to have one-on-one conversations if it's about a procedural question in the case, only if we need to have that real quick. And then I have to disclose that I had that conversation with the lawyer on the other side. And then obviously discussions are allowed if they're not connected to a case at all. I can see Jim in the hallway and tease him about Michigan State or something like that. That's no problem. Any other thoughts on that, or also on what kind of off the record communications occur? I think you covered them already between defense and prosecutor that don't involve the court. Any other thoughts on any of that?
I think too, it's brought up a lot. Sometimes people think that, if Jim was asking you, who won the football game in the hallway, that somehow that influences the case. But I think it's important for people to know we see each other all every day. But when we're in the courtroom in our roles, we're all doing our jobs, and it's different than socializing in the hallway, that it doesn't impact one way or the other.
Yes.
And I think I would go along with that too. And I think we're also super sensitive to that. We know that we're in a small community. We've known each other for years, and we go probably above and beyond to make sure that there's no even an impression of impropriety or anything like that. Because, I bump into the judge in the grocery store. Yeah, I'm going to chit chat for a second, but it's never about a case. The same, in all my years of practice, I've never had to worry that I thought a judge or a prosecutor or defense attorney was getting the ear of a judge in private. We just really make sure that doesn't happen so that there can never be, like I said, even a viewpoint of it, or even an appearance, is the word I'm looking for, an appearance of it.
Yeah, and there are rules about that, and if they're broken, attorneys can lose their law license and judges can get removed from the bench. There are bodies that can do that. But also, I think I referenced this earlier too. I mean, all three of us and a lot of the attorneys in town, any that have practiced for a while, we all know each other. We all have know each other generally, with rare exception in the local bar. I think the attorneys all get along. So certainly the three of us, we know each other, we respect each other, we like each other. But then this is where the law is not for everybody, because I said earlier, sometimes we're all irritated with each other, and that happens because of the cases we deal with are so important, and each of us bring different perspectives and different priorities to it. It would be troubling if we were never irritated with each other, because these are really high stakes and really important things. So, but we all can set that aside. And if someone's unable to set that aside, maybe the law is not for them. Because you do have to argue a lot and go to battle a lot, and then still be able to interact in a decent way with people. Couple of questions about defense representation. Do all local law firms have to take appointed cases on a rotating basis? No. And then how in theory or practice might a defendant expect their case to be treated differently if counsel's retained instead of appointed?
Well, I don't know if it's necessarily would be that it's going to be treated differently. Just to update whoever's the viewers, is that the state of Michigan a few years ago came through and really put in requirements for being a public defender. And that sort of goes back to the firms have to rotate. They can't rotate because a lot of the attorneys haven't gone through the training it takes to take court-appointed cases. I know next month I'm in training. They have special rules now that if you haven't practiced for a certain amount of time, you can't do indigent defense work for a county. The biggest difference I would see, and I really think the MDIC attorneys or public defenders or Office of Appointed Counsel, I do believe that they have or are probably as efficient as anybody because of doing it every day. They know the forums that they're in. They know the judges. They know the prosecutors. They're on top of their game. Where the biggest difference I think you're going to see between retained counsel and the public defender's office or Office of Assigned Counsel is probably in the amount of time that you get. I get to my office, there's numerous telephone calls. I can't get to everybody. I can always tell everybody that there will never be a time that you've gone into court and you have not talked to James Gelbert. But every time you call my office, I'm not going to be able to talk to you because I have quite a few cases and I have to get to everybody. Where retained counsel doesn't have that type of volume in cases, and they get paid for sitting on the phone and talking to you. So there's an incentive for a retained attorney. And if somebody's looking for that type of hand-holding or one-on-one, retained counsel is definitely the way to go. But I pulled some numbers real quick. Our office, and I'm focusing on Sheboygan County right now, our office in 2019, we did 610 cases between 3 attorneys. When COVID hit, that number dropped down to 449, and then those COVID numbers were moving because of over a little bit into the beginning of this year, but as of July, we're at 326. So you don't get as much one-on-one time with the attorney as some people, I'm sure everybody likes, or some people want. So.
Now, Melissa, from a prosecutor's perspective, I mean, obviously, the types of issues that a lawyer might raise in defending a case could certainly have an outcome in how the case might go. So, legal representation matters. But in a general way, does it matter to you whether a defendant is represented by a public attorney or a private attorney in how you would approach the case?
No, in fact, that's something that should really never come into play on who the attorney is and have that influence the offer. I think I'm conscious of that. And I think that the defense attorneys also watch that, and that's never been raised as an issue. It's about the case.
Well, that leads into the next topics that we got were about plea bargaining. How do you, as the prosecuting attorney, I mean, for people that don't know, I think most folks watching might know, our state constitutional system gives the Office of County Prosecuting Attorney a tremendous amount of power and authority. That's why they're elected by the people then. They're the chief law enforcement officer in a county, and they have 100% charging discretion. So it's not up to the other lawyers. It's not even up to the judge whether somebody is charged with a crime, what crimes they are charged with, what crimes the charge might be reduced to. That is 100% within the discretion of the elected prosecuting attorney. So how do you approach then a case? What factors might go into whether a plea bargain is offered and what type of plea bargain is offered?
There's actually a lot of factors, I think, that go into a plea offer, whether it's through reading the investigation, talking to the officers, talking to the defense attorneys as they inform me more about the defendant and who that person is, as well as getting the input from victims. So sometimes I can make everybody happy, sometimes I make nobody happy, and sometimes it's a mixture.
Okay, yeah, and I think I worked as an assistant prosecutor for a time. I never had the job that you have of the elected prosecutor, and that's a lot more responsibility and weight than I had to deal with down there. So I know that there's a lot involved in it, though, and I do think it's unique in that you have the only job where you are guaranteed to make everybody unhappy in the criminal justice system at some point in time. Defense attorneys are going to be unhappy with you from time to time. Judges are going to be unhappy with you from time to time. Police officers will, crime victims will, sometimes the public or segments of the public about a case, witnesses and defendants. So like every possible player in the criminal justice system at one time or another is going to be unhappy with the prosecutor. So that's a very, very difficult role. How do you navigate that with paying attention to input from people that matter to you, but without, I guess, without realizing that haters are going to hate, and realizing that you're not going to make people happy all the time?
Yeah, I think it's almost on a weekly basis that I hear you were too easy on a case and you were too hard on a case in the same week, and sometimes about the same case. Okay. But I think that you have to find your voice and your goals and your sense of fairness and try to make sure that you're listening to everybody, but find your path. Okay.
And then we had, I guess one more question about plea bargaining, I think is a good one. And I did a video on plea bargaining, so I might sit out this conversation. Folks can check out my thoughts on that. But I think it'd be great to hear the perspective of you both. What do you think are the benefits of the plea bargaining system? And are there risks to it, including, is there a risk that an innocent person might plead guilty for fear of the greater charges that are levied against them?
Who's going first?
I don't care. I think that my fear as a prosecutor, one of the worst things I think I can do is ever prosecute somebody who's innocent. So I think that I always have that in my mind, that I never want to do that. That is against my job description and what I'm here to do. So I try at all costs to prevent that.
Do you think that the plea bargaining system as a whole works? What are the benefits of that?
I do, because I think it takes into consideration factors where sometimes it's a good person that made a bad decision, or sometimes it's a really bad person that is a danger to the community. So through the plea bargaining process, you can make some of those determinations.
Jim, what about the defense perspective?
Well, and I think we definitely need the plea bargaining process. There'd be no way that our judicial system would function without it. And it's a cost benefit analysis right from the get-go. I don't believe any county could afford to try every case as they were charged. And I always joke a lot that there's a public defender economics course that I think I have to explain to people all the time, but a lot of our clients have free representation because they're indigent. And when you have free representation, it doesn't cost you anything to go to trial. And so if we receive an offer or plea that says plea to the charge, it doesn't harm our clients to take it to trial. And so if that's always going to be the case, that once you're charged with something, either you plead to it or you go to trial, there would be no end to trials, especially when it comes to the public defender's office. If you're retaining an attorney and you're saying, well, I did do it and they didn't charge me that hard and it's going to cost me a ton of money to go to trial, then that's a consideration that somebody retaining an attorney would take into consideration. But in regards to when the Constitution says that you get an attorney and one's appointed if you can't afford one, or and the statutes have said that, then when we've given that right to people, then the plea bargaining process has to come into effect. And a lot of times too, from the defense's perspective, it's a happy medium. Do I think there's the possibility that somebody might plead to something and they're not guilty of it? Absolutely. There is that possibility. And I do have those conversations with clients. One thing I can say about the prosecutor's office, I do agree with Melissa that she does take a lot of consideration into and listens to us when we say, it might not have went down quite that way, and she does listen to that perspective. We don't have a prosecutor's office that's just trying to get convictions. I can definitely say that. And but I think about different plea agreements that I've presented to clients where they're charged with maybe a CSC first, which if they're found guilty by a jury, they're going to prison for a long, long time. And if they take a plea, it's to a CSC fourth. As I tell clients, at the end of the day, they're the ones with the skin in the game. They've got to make the decision. If we lose, I go home, and that they're the ones that have to deal with the penalty. So yeah, I do believe that there's that risk that it could happen. It doesn't happen a lot, but it could happen.
And I think I did a whole video on plea bargaining, so I'll just refer people to go check that out for my thoughts on that process. Jim just said something that, we have a prosecutor's office that's not just trying to secure convictions. And I want to make sure anybody viewing understands that that's a high compliment and that's correct. That people might say, well, isn't that our job? And Melissa said something about that's not doing my job. And that's right, that the law has always recognized a prosecutor's job is not to secure convictions, but to do justice. And so that means if what is just is getting a conviction in that case, well, then that's the prosecutor's job. If what is just as they go through the case is to dismiss the case, then the prosecutor's doing their job if they dismiss the case. So I just want to make sure people don't misinterpret that comment, to Melissa's detriment. The final area that we had a couple of questions about were the Zoom and YouTube. One of them was interesting. How does a court assert jurisdiction by video over a defendant who's at their house? And I thought I could answer that real quick. Jurisdiction is not conferred by your physical appearance in court. That's always been true. If a defendant is charged with a crime and they're issued an appearance citation and they don't show up, they will get arrested, even though they've never been physically present in the courtroom. The court has jurisdiction over that case and over that person based on what they did in that jurisdiction. And the same thing in a civil case. If you get sued and you decide, well, I'm never going to show up in the court and therefore they don't have jurisdiction, you're going to get a default judgment entered against you. So jurisdiction has nothing to do with somebody physically showing up in court. It has to do with the actions that they committed in the court's jurisdiction. So that's that. But then another question, why are the trials not on Zoom or YouTube? Aren't they public as well? They are public, but I'm not putting them on the YouTube platform, mostly due to some practical issues. If you watch our stream, you'll see the jury box. And so if you show up for a jury trial and you're a juror, I have a legal obligation not to put your face and likeness out there in the public on video. There's a law about that. So I can't put the jury trials on YouTube the way we're configured. It would show the jurors' faces. We did do one trial that we put on YouTube where we had the jurors out in the gallery when we were not providing public access in the courtroom last summer. It ended up in a mistrial due to a COVID issue, but we're not intending to put the jury trials on YouTube for practical reasons. And also there are some issues with, for some types of trials, it would be a problem with, say, child victims of sexual assault. I think putting their testimony online would be problematic. Any thoughts on that from either of you? Or I guess just in general, lots of courts and lots of judges are doing this differently. What I'm doing right now is putting the criminal cases still on YouTube, the civil cases still on YouTube, family law cases I'm not putting on YouTube, and trials, jury trials, I'm not putting on YouTube. Although they are open to the public in the courtroom, I'm not putting them online. Do either of you have any thoughts about that as you've interacted with other courts and approaches to that, or any thoughts on that?
I know we've had a lot of positive feedback from our victims from the time that the live stream started and continued, that it's just been really convenient for them not to have to leave work, not to have to be in the same courtroom with the defendant, and that has worked out really well.
What do you think are the pros and cons of courts around the state continuing to put hearings on YouTube? Do you think that should continue or not?
Well, from my perspective, the activity about putting it on YouTube or on Zoom or Zooming things, I guess I may be more towards just having things on Zoom. When we went to the whole Zoom format, it added a lot of work for us. Due to the fact that clients no longer were required to come to the courthouse. Now in circuit court they are, so that we're meeting with our clients and we're actually in the courtroom. So that being streamed, I have no position on, or I think it's fine. But when it's just Zoom, for that year there when we were Zooming all the time, it was a lot of work because we were tracking people down and they weren't required, and everybody changes their telephone number every day, and it added a lot of work to us.
Any other thoughts on the pros and cons of that? And Melissa, do you have any objection to us continuing to put that on?
No, and I think that as far as the Zoom part, I think the hybrid has been really nice because each case has its own circumstances and needs. And I think the court has been good, as well as the defense attorneys, and talking about what the needs are and how to go about doing hearings. And I think that it's worked very smoothly.
Yeah, so far right now, most of our criminal cases, or just speaking for me, most of the criminal cases I preside over are in person, but some were using Zoom as a convenience for people, defendants and victims and lawyers and witnesses. The civil cases, most of it is on Zoom, but we're allowing people in person, if that's what makes sense for their case. But stay tuned, because I was at a judges conference, and I can tell you, my sense is that most trial judges in the state do not like putting anything on YouTube. And there are some very valid concerns about that. Some judges, and I'm one of them, I think it's a good thing for courts to have more transparency and accountability for what happens. And it's more educational for the community to know what's going on. but we're going to have to wait and see. I suspect we might get some rules or parameters from the Supreme Court about that. But as of right now, it's sort of up to each individual court. All right, any final thoughts on any behind the scenes stuff or our different roles in the justice system? Or?
Just that everybody came up with really great questions. I think it was quite diverse on all the subjects that were covered.
Okay.
It's fun. Thank you.
Yeah, and no, I enjoyed the opportunity, and I thought it was fun.
Yeah, and thank you both so much for taking over an hour of your time to have the discussion. It's fun for me to talk about these things with you and get your perspectives on it. And I'm sure that it's a lot of insight for anybody that'll watch these videos. So thank you so much for joining me for this. And as I say in all these videos, I'll see you in court. All three of us, we'll see you in court.
Thank you.
All right, have a good day.